we have all kinds of properties. I have cash in my wallet. I have a house. I build a fence around it. I lock my door to protect my property. But we also have ideas. How do we protect those ideas? How do these ideas get protected? Well, we have four what I call flavors of intellectual property protection. We have our trademarks. The trademarks are any kind of your brands, your logos, symbols, anything that a consumer would go to the marketplace, they would go to the aisle, and they want to see on the aisle, they recognize the brand, and they know who the source of that product is. That's a trademark. Very powerful, because some people will shop basically on trademark.
Welcome back to another episode here on the Business Breakthrough Podcast. We just had, you guys just saw our last podcast that came out was with Brian Freed. We talked about inventors, inventions, and we dabbled a little bit into the patents and trademarks side of things, but we held back because we knew that we had another special guest coming up, and he is here with us today. Welcome to the show, Will Salas. Okay, I had a buddy that I worked with in the Army whose name, same spelling, went by Salas, and so I kept getting that messed up.
Yeah, if you want the ethnic actual pronunciation, it's Salas. Yeah, it's South American, but it's been Americanized as Salas, and I just rolled with it.
There you go. Okay,
yes.
Easy peasy.
Yeah, I too was in the Army.
And outstanding.
I can remember that moment just like yesterday, meeting the first Salas that I didn't know. He's got his name tag. I'm like, look, we looked at each other, shook hands. He's from Puerto Rico. I'm from here, and I say Salas. I'm like, Salas. That's how I roll.
Yeah, now we can distinguish between each other.
Yes.
No, that's a lot of fun. Yeah, you get to meet a lot of those people in the military. So I'm actually curious then, from your time in the military, how did you get into the position? I guess first we can give people a little bit of your current background to let them know your expertise and everything as it comes to patents and trademarks.
Yeah, so I'm a librarian first. We wear a lot of hats, and there's something called the Patent and Trademark Resource Center. It's a nationwide consortium of libraries, about 85 of them, and they work with the Patent and Trademark Office. They get accredited. They have to go through a training process. There's a site visit. The trainings pre-COVID were really excellent because you were required to, your library was required to send you to Alexandria, Virginia every year.
Wow.
Which was fantastic. I mean, I'm only here on Long Island, so it's a short trip I drove, but I would have colleagues from Hawaii coming, Puerto Rico coming, and it was fantastic to meet with some of them. Alexandria is the headquarters of the patent office. It's right next to Old Town. It was a lovely place to visit. I got to walk to work for a while, met with a lot of colleagues that were in the same boat as I was, learned from them, and I've been doing it so many years now, maybe some of them are learning from me. But we get to work there. Very swanky offices. If you ever get a chance to go to the Alexandria, Virginia office, the first floor is open to the public.
Oh, wow.
Yeah, it's the first floor is where they house the museum, an Inventors museum. The other, like a third of the floor or half of the floor is a public search facility where everyday people can go in, but it's mostly going to be a lot of attorneys who go in and use the actual facilities there at the Patent and Trademark Office. Mm-hmm. That was significant up until a little while ago because the Patent Office made its information available for inventors to look at, for entrepreneurs to look at through their servers. So there was a lot of security around it. Right. So very few libraries, like the 85 libraries like ours, the Patent and Trademark Resource Centers, a while ago, we had a special fob and a special login where the attorneys could come and visit us and get access to the very same servers as they would have if they had to fly to Alexandria and get access.
Wow.
So I had attorneys who would visit so often, they set us up with brand new monitors all over the place so that their workplace, so that our workplace and my library would look more like their workplace because they were spending so much time with us.
That's incredible. Yeah, to expand that resource and to make it more accessible. I mean, that's such a brilliant move. And then you're not, especially with the central, like the main place being on the East Coast and so far away, just like you said, from places like Hawaii.
Oh, everybody wins. We get people coming to the library. The Patent and Trademark Office wins because their goal is really to get the word out to everybody, everyday people. They don't get like a regular stipend or an allowance every year to function. They have to have people apply because they thrive off their application fees and maintenance fees.
Got it.
So it behooves them to get people, make them aware of them. And that's why we kind of exist. I forget the title, U.S. Title Code 35 something or other, which allows them to allow us to offer these kinds of services to make everyday people aware of what patents and trademarks are and the demonstrations that we show them.
Outstanding. Well, and that's exactly why we wanted to bring you on today.
Thank you.
So can we let's start super basic. Mm-hmm. What is a patent? What is a trademark? And what is the difference?
Okay. It all kind of falls under intellectual property protection. Okay. So we have all kinds of properties. I have cash in my wallet. I have a house. I build a fence around it. I lock my door to protect my property. But we also have ideas. How do we protect those ideas? We can't put, a fence around our heads or cover our heads with tinfoil. How do these ideas get protected? Well, we have 4 what I call flavors of what we call intellectual property protection. We have our trademarks. The trademarks are any kind of your brands, your logos, symbols, anything that a consumer would go to the marketplace, they would go to the aisle, and they want to see on the aisle, they recognize the brand, and they know who the source of that product is. That's a trademark. Very powerful, because some people will shop basically on trademarks. How many times as a kid did you go to the shoe store and you saw that Nike swoosh? You gravitated right toward it because you knew the other kids would think you're cool wearing Nikes.
Exactly. It's the power of brand, 100%.
Exactly. So trademark, and then there's patents. Patents for a brand new invention. Any kind of new device, new article of manufacture, a new machine. Article of manufacture, think of pencils. They come out of the factory. They don't have any moving parts, so they call them a new article of manufacture. A new machine has working parts. Any new composition of matter or any new improvement upon existing inventions could get a patent. So that what you get is a grant from the government that says you are the owner and you get a legalized monopoly for 20 years, 15 years if it's a design patent, and I can go into the difference of the 3 different patents later. But basically it's saying that you are the owner of this patent, this idea, and no one else can profit from it from you. You're the only one who can import it to the United States, sell it, build it, what have you, but only in the United States and its territories, because patent offices are sometimes country-specific, sometimes they're regional. So sometimes an inventor will find out the hard way that they get a U.S. patent granted to them, and they'll arrange to have 1,000 units or 100,000 units built for them in Mexico or China. Well, you're not protected in those countries. So now that manufacturer of halfway around the world, he might produce your 100,000 units and sell them to you, but he might make another 100,000 units and sell them elsewhere because because you didn't protect yourself elsewhere. There's no such thing as one international patent that protects you all over the world.
Okay. So how does one go about if you're in that situation and you want to be able to produce these at a lower cost and have the production and everything occur outside of the United States, which is, I imagine, is typically the reason why people do it. How can you protect yourself in other countries if you're trying to manufacture there?
Yeah, a lot of people ask that question. If you have the means, fantastic. But a lot of the kind of inventors that I meet up with are your students, sometimes like doctors, a lot of contractors, stay-at-home moms and dads. They don't necessarily have the means to do that, but it's possible. You can't do it everywhere all at once. There's something called a patent cooperative treaty where you can follow your paperwork internationally, but you still have to apply to each of the patent offices or regions around the world. Like I said, are country-specific, like the U.S. and Canada and Japan. Mm-hmm. Some of them regional, like the European Patent Office is regional. It's over 30 countries involved.
Oh, wow.
So you have a market in that area, and it's very important to you, then you might go ahead and file for patent protection in that area.
Okay, well, that makes sense. And I know one of the things that we talked about with Brian were when you're taking a prototype or something like that to a manufacturer is considering non-disclosure agreements. Can those work cross-country border? I mean, essentially, it's a contract that you're signing up for or that you're agreeing to. Mm-hmm. But I guess, I don't know, if I'm a Mexican or if I'm a Chinese manufacturer and you have me sign an NDA, what kind of recourse do you have to even execute upon, like, if I violate that NDA, what are you going to do? Especially going back to, a lot of this goes back to the means. Like, how much money do you have to actually pursue using the protections that you have, even when it comes to patents and trademarks?
So that brings me back to, like, sometimes I begin my sessions with patrons who come visit me, what I can and what I cannot do. Mm-hmm. I wear a lot of hats at the library, but ultimately I'm a librarian. I'm not an attorney, so I don't give legal advice, and I can't give business advice.
Right.
I've had people ask me and try to solicit legal advice from me all the time.
It makes sense because it flows right into it.
They kind of see me as that kind of authority because I'm the face of the Patent and Trademark Office for them, which is wonderful. I want to be that for them, but I have my limitations.
Yep.
And business advice. They'll ask me, is this going to be a good product? I'm like, I wish I could tell you, but who knew the pet rock was going to do so well? I'm sure the person who came out with that idea was told no 1,000 times.
100%.
Just think of, like, because I'm a librarian, I'll say J.K. Rowling she was turned down like 30 times for her book. But guess who won?
Oh, yeah.
Yes, now the richest woman in the UK, I believe.
That's incredible. And well-deserved. She created multiple masterpieces that everyone was just head over heels for.
What a legacy. It'll go on forever. But as far as that, I don't know about non-disclosure agreements. I think it'll be as strong as it can be enforced in that other countries. If you spread yourself too thin, if you're representing yourself elsewhere, you have to have some representation. It probably helped to have representation in that country, kind of like in the U.S. now. If you're going to get a trademark in the U.S., and we attract a lot of foreign business. For instance, patents, you don't have to be a citizen of the U.S. You don't have to be of age. You can be incarcerated. You can be deceased, and your estate can still get a patent for you. So we'll take patent applications from anyone. Now, with trademarks, it started to get a little more difficult because there were certain bad players who were trying to flood our trademark office with bogus applications, just clogging up the works and then possibly getting trademarks for certain marks in certain industries and then ruining it for others. One of the things about trademarks, to maintain your trademark, you have to be in commerce. So if I have a trademark for, let's say, water bottles, and I have let's say, a shamrock on there, and I'm just a bogus company, I'm just doing it just so I can get money elsewhere on the other end, that means I'm blocking someone else who may want to use a shamrock on their water bottles. So as part of maintaining your trademark, you have to prove that you're in commerce.
Wow, so you have to show that you're actually making sales.
Yes, and in the beginning, you have to show what they call a specimen when you're applying. You have to show a photo of your mark on your product. And that sometimes will scare new people off because they figure, oh, I have an idea for a business, I'm on my way, but I don't have a product, I'm not selling it. There's an intent to use form that you could use so that you can secure that mark for your product. It gives you 6 months to prove that you have that mark. Then if that you run out of time, you can extend it up to 5 times.
Oh, wow. Yeah. That's great. So you have some flexibility there to make
sure.
to make it happen. Okay. So when looking at the different kinds of patents then, I know I've heard terms like patent pending, utility patent, and things like that. Can you kind of dive into those and break down what each of those mean?
There are 3 types of patents. There's utility patents. When you talk about patents, 90% of the time people talk about patents. It's a utility patent for a brand new invention or something that has some functionality to it. Then there's your design patents. Think of just cosmetics. I always think of Steve Jobs when I think of design patents. He didn't invent the iPod, but he gave it those nice little curved edges and rounded buttons. You're protecting the ornamentation of the device.
Interesting. Okay, so that's the design patent.
That's a design patent. Okay. Our friend Brian Fried has several design patents.
Okay,
yeah. You just make it look cooler, different, and you can protect that. And that lasts for 15 years. And the last one is the most obscure one. It's a plant patent. It's exactly what it sounds like. Your trees, your shrubs, your berries, your fruits, you can get a patent for those. If you can asexually reproduce a brand new variety of that, then for all the work that you've gone through, all the research, all the development, all the sweat and tears and pain to create that, you should be rewarded with a monopoly on that. And one of my favorite plant patents is for the Honeycrisp apple.
Oh, I had no idea.
Oh, yeah. It's the University of Wisconsin, I believe, invented it, and then they would get, I think, like $100 per tree after having secured that patent.
Get out of here. That's crazy.
Yes.
Did you know that, Sarah? I had no clue. That's amazing. And so, okay, how does the patent pending side of things work? And what's the purpose and utility of that?
So the patent pending is, as your idea is kind of fleshing itself out, you're on a timer, because what inventions basically are fix-its. Like there's a problem, like you're not having very good luck catching the mice in your corner of your house. So you've come up with an idea yourself. You just solved a problem that many thousands or others may also have. So you think to yourself, well, I just tooled together and engineered this little gizmo. Maybe others could use it. So you're on a timer, because there could be other people who have rat infestations who have the same idea. Tinkerers, manufacturers, engineers, all of them may have the same idea. So it's the first one who could able to articulate that, put it into paper, and file a provisional patent application will get that idea. Now, the provisional patent application is really fun because it's just a timestamp that says that Matt had this idea on July 23rd. Is it the 3rd? 5th, 25th? 6th.
Time flies.
Matt had this idea on July 26, 2024. That point forward, you have a timestamp that you were the first one to have that idea. Now you have a year's time from then to file what we call an RPA, regular patent application. Okay. We refer to provisional patent applications as PPAs. Okay. In that year's time, you're trying to do a patentability search, which is what I help people do, find out if anyone has already come up with that idea. And you're also going to be talking to businesses like small business development centers, businesses like SCORE, Service Corps of Retired Executives, to see if this really is an idea that's going to make you money. And that's what a provisional patent application can do for you. It's a watered-down version of a patent. You don't have to include everything that a regular patent application would include, but it would behoove you to include as much as you can. Make it as close to a regular patent application as you can, because you're only protected for what's in the provisional patent application. And if you file it in early on and your invention fleshes itself out and changes, you find a better mode for it, those changes aren't protected unless you file yet another provisional patent application to protect those changes. And now the provisional patent application, it's only an application, it's not a patent. The patent office, they're not even going to review it. They will not look at it unless it becomes relevant. And how it becomes relevant is that in a year's time, you file for your regular patent application, and that gets granted to you. You get your 20 years for your regular patent application, but you also get backdated a whole year. So you get 21 years. You bought yourself an extra year.
Oh, wow. Okay.
Right.
So, okay, I'm curious. So walking through this, trying to put on the perspective of somebody who's come up with a new idea, and they want to come to your office to have some research done to figure out, like, am I actually the first one to market with this? Am I the first one to patent?
Right.
Are there any tips or anything that you or suggestions that you would give those individuals of things they should accomplish or kind of a checklist that they should go through before they come and see you? Like, where are you at in the kind of order of things?
As soon as you wake up and you tell your wife, you know what, I'm going to change the world. This is a new idea, but I don't know where to go next. That's when you want to come and see me.
Okay,
because a lot of people, they sit in their heels and they wait and they wait. And I can't tell you how many times I've had inventors come in and say, oh, do you remember that gizmo? I invented that years ago, but I just kept waiting and waiting and waiting. Don't sit on your haunches. You got to find out right away, because you know what? That dream is going to keep chasing you if you don't try to do something. If you don't act on it, it'll just nag at you.
And then you're going to see it on QVC and someone else is selling it.
It's bittersweet. You know, I have a lot of inventors who find out that something, I myself had several invention ideas, and it's bittersweet because first you find out if someone did invent it, it already exists. If it's A, someone else thought it was a good idea, so you feel validated. B, someone else thought of it before you, so you feel like I got back to the drawing board. Or you can tweak your invention around it, which is what most inventions are, is improvements or differences of what already exists. And if your difference to that previous patent is different enough, you may be able to get a patent on it.
Right. No, that makes sense. And that, yeah, that absolutely makes sense, because you're just kind of looking around you. I know that Brian and I dove into this deep, just looking at the little problems or even things that just bother you, even if it's not necessarily like a problem, but you're like, oh, I don't enjoy this part of doing this simple task. What is a way that this could be done easier?
I love that you keep bringing up Brian. Brian, like I said, off camera, I kind of live vicariously through him, because I have no patents yet, but he's got over a dozen patents.
Right.
But what really makes him special is the way he's able to market things and sees the world, and he gets things out there. I'm sure you've heard all of his stories, but maybe you heard a story of his first patent.
We started to dive into that. I think we covered a bit, but please go in and dive into it.
Yeah, so this is not my story. This is his. So
yeah.
He takes his daughter to an amusement park, buys like a $35 Mylar balloon. She loses it. On the first ride she goes on, she loses it. And Brian's like, there goes $35. So he's just tinkering. He makes a bracelet that holds balloons. And that's his first invention. Very simple things
So
like that.
simple.
It's my favorite inventions are the ones that have no moving parts. Are just very simple. Because when pre-COVID, I did school visits, and I would visit up as young as like second graders.
Wow.
And one of the first things I would ask, what does an inventor look like? And some kid would raise their hand and they describe something that looks like Einstein, white coat, long beard. And I said, no, look next to you. Those are inventors. And then I would tell them stories about young inventors their age. Like a boy, I think Michael something or other, he went on vacation to Hawaii. And he and his dad liked to go diving, so they would go swimming underwater. And he sees this really interesting coral. He looks over to his dad and he goes, blah, 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 blah. And he realizes, I can't speak to anyone underwater. Over the next year, he goes and he rents time in his local swimming pool, and he invents the underwater walkie-talkie.
Get out of
Yes, so
here.
now we can speak underwater. And then this is back when Toys R Us was still around.
Jeez.
Later, after he gets his patent, he sells it to Toys R Us for almost $1 million.
Oh my goodness.
And this all stemmed from trying to solve a problem from speaking underwater.
I can't believe that that happened so long ago, and I had no idea that those existed. I would absolutely be interested in those, especially with my kids at the pool and everything. That'd be so much fun.
Those are my favorite. Yeah.
And it's just and there it is. You're enjoying yourself. You're having a good time. And you see yourself run into that problem, and then it's just kind of that conviction. It's taking that next step to say, yeah, I'm going to solve this. I'm going to invest time and energy to find a way to make this work.
Yeah, those are great inventions.
I love it. I absolutely love it. So what can someone expect? One, again, tell everyone where you're located, and then when they're coming in, what can they kind of expect from you and from that experience?
Okay. So I'm at the Smithtown Library. We're centrally located, the biggest library district in Suffolk County, and I think all of Long Island. We're at 1 North Country Road in Smithtown.
Got it.
But you don't have to make your way all the way to see me. We now offer, thanks to COVID, virtual visits.
Oh, wow.
So I was just, I think, telling Erica Chase off screen that I was very proud that last year, in 2023, I had my very first international trademark appointment.
That's incredible.
Yeah, through Google Meet. It was a really interesting young lady. She was, I don't want to give up too much, I don't want to give up her information.
Right, of course.
She's a student from the United States, and she was in Moldova studying and teaching there. And while she was there, she created a travel business. So she wanted to know how she can trademark a logo. So I get her, it's 2:30 my time. It's like 9:30 her time. She didn't fall asleep, to her credit, but I was jazzed, and I told my administration, they were jazzed. Like, I just had my first international trademark appointment, and it was wonderful. So you don't have to come in to see me. If you can't make it, you're busy, you're very busy, we can meet virtually.
Okay.
But what happens is when you come visit me or virtually, I will first show you how to access. First, I kind kind of decipher what it is you need, a trademark search or a patent search. Some people don't know anything about intellectual property, so we can start right from there. I show them how to get a MyUSPTO account. So if you're going to do business with the USPTO, you need a MyUSPTO account. That covers you for both patents and trademarks. However, with trademarks, because of all that nefarious activity from overseas, you now have to have an ID.me account to be able to prove you are who you say you are. And then I show them the databases. And the databases have both changed dramatically in the last couple of years. About 2 or 3 years, almost 3 years ago, the Patent Office created a brand new search database, which now negates the fact that people will have to come and see me to get access to the servers. Now anyone can access this database.
Wow.
Which is great. Bringing government information to people is what we do.
Absolutely.
But when it was being designed, it was designed to be like the one-all database for everyone, even the patent examiners, and it didn't quite work out. So the patent examiners still use their own database,
okay,
but the one that's available to the public was being designed with the patent examiner in mind, so it's kind of complicated. When you open it, there's 3 different screens, and it's like I tell people, it's like you show up in a Ford F-150 and we put you into a Ford F-16. It's all of a sudden you feel like you're in a cockpit. You have too many decisions to make. You don't know where to go. And it can be daunting. It could turn people off. And that's the benefit of seeing me. I'll explain it all to you, and I'll show you how it works, and I'll even demonstrate a patent search for you.
I can attest to that exact experience, because as I was getting clients that had it, I was like, okay, what does this actually look like if I went onto the site and tried to do it? I ran into that same exact thing, and I was like, I feel like if you understand how to use this, it's very good. But I have no idea how to use it, and I have no idea how to figure out how to use it. And so you have an expert right at your hands. So you had an international, I think this may answer the question. So you just had an international call. So does that mean that anyone, are the responsibilities broken up regionally based on the 85 different libraries that cover this? Or can someone from California reach out to you? Can someone from Texas reach out to you specifically?
Nope. We don't really screen clients. They just come as they come. I had someone from Philadelphia come see me. I didn't take the phone call. Someone else took the message for me. And then the next day, I'm like, what? They're coming from Philadelphia. They passed 2 or 3 patent and trademark resource centers just to get to me. So when she arrives, why did you come? Oh, I was visiting family, so I just wanted to see you since I was in town. I was like, oh, thank goodness, because if you're coming this way, I really got to put on a dance party for you.
Yeah, exactly. We're busting out all the balloons.
Really?
That's incredible. Okay, so if people wanted to get in touch with you at the office and schedule an appointment or anything like that, how would they do that?
They can visit the Smithtown Library website. It's smithlib.org, spelled SMITHLIB.org. Or you can email me directly. It's my first initial, my last name. That's WSALAS at smithlib.org.
Okay, perfect. And I wanted to save this for the end because we can just chop it out if it doesn't work. Do you know anything, or can you speak about copyright and things of that nature?
Well, I know a little bit about copyright because I get asked enough. Copyright's going to protect your artistic works. That's one of the other flavors of intellectual property protection I forgot to mention earlier. That protects your artistic works, your screenplays, your song, your lyrics, your choreography, your artwork. Some people come into me and they want to trademark something, and it turns out they just want to copyright because they have a T-shirt shop and they have 2 or 3 dozen T-shirts, and I say, well, are these images going to appear on each of your T-shirts? Oh, no, they're all different. I'm like, well, that's copyright. It's not exactly...
Interesting.
Yeah, your trademark would be the logo that appears on the lapel or the collar on each of your shirts.
That consistent thing that is like your business logo that's always there.
So the consumer knows that's a shirt made by XYZ, but the images each will be copyrighted. And copyright is implied as soon as it's public. So you don't have to run out and copyright it right away. However, if you find someone has infringed upon your copyright, now, if you want to take them to court, you do have to get the copyright protection and then take them to court. And copyright infringement means that they're stealing your idea, your words verbatim. The ideas you express in your book are not protected.
Yeah, so those specific words, they can't. It's like you can't plagiarize.
Right, like we mentioned J.K. Rowling earlier. Right. So J.K. Rowling had in her books the school Hogwarts. So Hogwarts is an idea that she created, and she can get copyright protection if you steal pages out of the book that mentions Hogwarts. But you can also write a book about Hogwarts yourself, and you can take ideas from her book. Yeah.
And that's become kind of a popular thing. I know that my oldest daughter got into that for a good long bit, is fan fiction. Right. Writing it, reading it, like talking with others who are playing in that kind of space. And so it's kind of cool that that's open, and so that people can even expand upon
it is and
things.
It isn't. To a certain extent. Like a lot of fan fiction comes out of Star Wars. If you see there's a lot of Star Wars fan fiction. So I met a gentleman who was somewhat involved with that, and people ask him, well, why doesn't George Lucas, who's known for protecting his work, go after them? It's like they're just small game. they're just not worth it. You're going to go after them for what? They didn't make money off of the product. Maybe if it was a really good fan fiction, they'd made some money off of it, but it would cost you more going after them than it would whatever you can gain from them. Kind of like how cyber squatting has happened. Like cyber squatters know that there's a certain dollar amount that companies will go after you for to get you to stop using what they want to use, and they'll settle at that price constantly.
Wow.
Yeah.
Wow, that's incredible. That's amazing. Are there any other tips or anything that you want to tell people before we wrap things up?
Yeah, a lot of people have ideas. They're going to fix something and it's going to change the world, and they want to tell everyone. They want to shout it off the mountaintops, and that's exactly what you don't want to do. You want to get some intellectual property protection first. So get that provisional patent application. It's fairly cheap, depending on your situation. When you go visit the uspto.gov website, there's a Find It Fast button, and it has most of the pertinent things there right away. At the bottom of the Find It Fast column, you'll see prices for patents and trademarks. To get a provisional patent application, for most people, it's like $60, $70. A really cheap hit to take if it doesn't work out for you.
Right.
If you qualify as what they call a microentity. So the three columns are regular fees for your corporations and your businesses. Then there's something called a small entity for certain individuals, your nonprofits, your universities. Then there's something called a microentity. You're getting a huge discount. And the microentity, to qualify as a microentity, you have your name on 4 or fewer patent applications because they're trying to reach out to the new guy or gal. And you have to employ less than 500 people. And you can't be obliged, like if you're working on Farmingdale State College's time and their equipment, you might have to share your invention with them. And then Farmingdale may not qualify as a microentity.
Interesting.
So, But if you're doing this kind of work on your own time with your buddy in your garage, then it's your invention and you don't have to share it with anyone. So long as you're not sharing it with someone that doesn't qualify as a microentity, you can still get the microentity. And the last thing for a microentity status is income level. If you're making less than 3 times the national median income, so it roughly comes out to about $200-something thousand in the tax year prior to your application, then you can get a microentity status. Okay. And that microentity status goes off with all the payments that you'll be going through, up through the issue the payment.
Okay.
So it's a lot of fees. There's a lot of fees up front.
Right. You said 4 different patents pending, or what was that stipulation for making it into the micro category? It was just 4 different patents that are submitted for, or what was that again?
4 different patent applications.
Applications.
So I imagine, and I would ask you to double check on that. I don't think the provisional patent applications would count.
Okay.
Because once a provisional patent application expires, I don't think there's any record of it.
Right. Okay. No, that makes sense. Yeah, and that's what I wanted some clarity on. Okay, cool. That's amazing.
And my other tip of advice is to, again, like I said earlier, don't sit back and wait because someone else will come up with an idea to fix that same problem. And once you have that provisional patent application, you don't get that money back. You don't get that refunded to you if it's discovered that it belongs elsewhere. So to get a patent, not everything can be patented. So to get a patent, it has to have 4 things have to happen. First, it has to fit into a statutory class. Like I mentioned earlier, it has to be a new device, a new machine, new composition and matter, an improvement upon those. And then also it has to have novelty. It has to be new to the whole world, not just patent offices. A lot of people think they just have to check the U.S. patent office and they don't find that they're fine. But no, they have to check patent offices all over the world.
Interesting.
And not just patent offices. When you invent that new mousetrap, it's going to go to an examiner who is an expert on mousetraps. He or she will know all the trade shows, magazines, websites, and all the patent offices all over the world. And so even if your idea is not patented, if it's being sold somewhere or if it's mentioned in some graduate student's paper in Australia, the patent examiner will find that, and that's called a prior art search. You're looking for any prior art, any publication of your work. If that's found, then you're going to be denied those claims as part of your patent application. And what's scary part is, I found out the hard way, when you file for a patent, your patent goes into the application database. But the application data, it doesn't populate in the application database until it's been in there for 18 months.
Oh, wow.
So somebody could be 6, 12, 14 months ahead of you. You won't know until it pops out on the other end. So nobody, not anyone, not even a law firm, can guarantee you a patent unless you know all the players who are involved in the industry and what they're doing. So there's always going to be a leap of faith. And that's what you really need, because it's a hard thing to do. It's not easy. And once you get that patent, the big misconception is that you're going to be rich and famous. No, that's not quite it. 90% of the patents don't make it to market, and the few that do, that not all of them are commercially successful. Right. Brian Fried, who we spoke about earlier, he's incredibly successful because not only has he spent a lifetime knowing the ins and outs and developing networks, he has the ambition and he has the stamina to do this. When he does his day job, He does his inventing, and then every night he's on the phone with other foreign countries about how he's getting his products manufactured, how they're being brought over. He hustles, and for him, it's like his hobby. I believe that he's at his best, he's at his happiest when he's doing this.
Yeah,
and that's why he's successful.
Full of passion and just and one of those natural networkers, and has that, not just the passion and not just the network, but that instinctual drive.
He does,
just to push forward. Every time that he comes into the studio or comes into the office here, he's always on the phone. He's always on the phone, like, all right, give me a couple minutes and I'll be ready to go. And because he's like talking. Yeah, exactly. And so there's a lot of work. And the thing is, I'm not even saying that you have to have all of those personality traits necessarily in order to get something successfully patented and get it successfully to market. Brian has basically extended himself through his community, through the National Inventors Club and through the Smart Inventors app that he just came out with in October of last year, to be able to afford to help you expand your network and understanding of everything.
Oh, yeah.
So
they call him the inventor coach for a reason.
That's right.
Yeah,
That's
he's the one who you want to go to get your idea from an idea to on the marketplace.
So reaching out to Will and reaching out to Brian are definite steps that we would recommend that you take, if you're in that position, if you just came up with that idea and you want to see how it goes. When it comes to the art, the previous art that you were talking about,
right.
How can somebody do their best to be able to try to figure that out? If it's
good idea, good question. The patent office teaches me and other patent and trademark research center representatives what they teach us is to do a preliminary patent search. Okay. So what that includes is the top 3 patent offices around the world: the U.S., the European, and the Japanese patent office. So when you do come and visit with me for a patent appointment, I will show you the U.S. patent office, the European patent office, and the Japanese patent office. Once you've exhausted those 3, you do not see your invention out there, then you're better informed about whether you want to go ahead and make an investment on this idea. Because remember, time is ticking. There could be others who may have that same solution to that problem you're trying to solve. And then once you get your provisional patent application, you want to continue searching all the other patent offices around the world, but not just patent offices. I found invention ideas of my own: Yahoo and Google Images, Alibaba, or what's the other big one? Not Temu, eBay.
Oh, yeah.
eBay and everywhere. So that's kind of frustrating, but...
Yeah, and so those are places to go and check too. So while you're going and getting the official patent resources, like checking in on all of those,
right,
hop online,
and then you'll see patent pending on them. That's why I couldn't find it. It's still in the phase where it hasn't been published.
Got it. Yes. Okay.
And before we go, I got to shout out to my daughter, Victoria Elizabeth Salas. She inspired me one day when I saw her doing something, and I'd never seen anyone do it before. And that was an idea that she and I had tried to take and found that it could be patented. And we're still I got a little lazy on that one. I'm guilty of my own advice. I've stayed on my haunches, kind of been sitting back on it. Victoria, one of these days you and I will have a patent.
Go. And shout out to Victoria. Let's go.
That reminds me, one of the things about patents, one of the 4 things about patents is it also has to be not just new to the whole world. It has to function. Some guys are really kind of vain and they just want to add a patent to their trophy wall. That's not going to work. You have some guys who just want to put a bunch of nuts and bolts together and say, hey, look, that's a patent. Give me a patent. Not true. It's sculpture. It's got to have some functionality.
Got it.
And the other thing it has to have is non-obvious. Now, that's a little more difficult to explain. If somebody who's skilled in the art would have anticipated your invention, then it's not going to be an invention. It has to have like an aha moment where you would not have anticipated that. For instance, if there's like a brand new aluminum alloy and you're a bicycle frame maker, if you're the first one to make a bicycle frame with that aluminum alloy, that's not a brand new invention because eventually other frame makers will also use that metal.
Oh, okay.
Yeah.
Okay.
So
that makes sense.
So it has to have some kind of element that would not have been anticipated by someone who's skilled in the art.
It'd be like a new bike design. Like now the wheels are side by side instead of, front and back.
Something
like
different enough than what exists.
Okay. You folks out there want more information and you have an idea, then you have the avenues to go. You got Will at your back. You have Brian Freed. You can join his community, and so you have resources. It's probably never been easier, and it's never been easier to gain access to the resources, to talk to the people to help you to figure out whether or not you should take that leap. Because the leap never goes away. There's always the leap.
It's always going to be scary when you think that there's going to be money on the line and your money on the line. So you got to build a team around yourself. You can't do it all by yourself. So you just try to benefit from the people who've done it before you who want to give back. And everything I show you at the Smithtown Library, it's all free. So visit me at Smithtown Library.
I was going to ask.
Smithlib.org. Contact me. Be happy to sit with you for an hour or so, give you a demonstration. And you can always come back to ask me further questions.
It's completely free, people. Go check it out. Well, thank you so much. Really appreciate it.
My pleasure, Matt.